Mr. Humphreys, over the short adjournment, Lady Arden, and perhaps assisted by her judicial assistant, has copied for our use certain pages out of the Hayden 4th edition Restraint of Trade Doctrine. And you're now being handed copies of 3 pages, as of course is Mr. Dunlop and Mr. Fletcher. I vote that we don't all read it now, but that tomorrow we receive any submissions on it.
Indeed. That
you or Mr. Dunlop would like to proffer. Is that acceptable?
Absolutely, my Lord.
Good.
Thank you for
that. Then we put that on one side for the moment, and we turn to the work that you have or have not done over the short adjournment.
Well, one thing we've all now arrived at is that Justice Hayden, of course, has published 4 editions of this.
You've got
work,
the book.
And we acquired a copy.
Right. Have we got a bit of it in our papers?
No, there isn't. There isn't.
Yeah. We did know about it because we looked at it for the purposes of the Egon Zender case.
I see. The issue raised about the butcher shops, if one likes, was first raised by Justice Hayden in 1969 in his Law Quarterly Review article, when he conducted an analysis just after the judgment in Esso Petroleum.
Well, we've got that in our authorities, and it makes fairly exciting reading.
Yes, he's rather more scathing than one comes across.
Indeed.
Academics.
What about 1999?
So 1999 is the 2nd edition of this book. So that's where he raises the same issue, but this time in the course of his textbook, and we are getting the 1999 2nd edition. If it's needed.
I don't think sure that would be worth it.
And the same problem is again promulgated by him at page 70 of the 4th edition.
Right.
So but oughtn't we to have the up-to-date consideration by Justice Hayden of the issue, rather than the historic one?
Yes.
Yes, well, that I think is what you were saying.
He still says these are the potential difficulties. He doesn't proffer any more answers. He simply flies the.
But is that in the page we've got?
No.
I rather think it's not.
No.
Perhaps we should arrange for copies of that as well.
I mean, the pages we've got, which we'll look at tomorrow,
do
seem to have some fairly pertinent points.
Yes, my Lord.
Relevant to the facts of this case.
The anomalies are still the same anomalies, albeit worded slightly differently, I think.
Well, then I vote we don't bother with the 1999 2nd edition.
Very good. So
right, what else?
Also, helpfully, from the same source, we were able to pull together a list of the Australian cases, because as one might expect, they receive quite a bit of coverage in this text. And in one particular footnote, he talks about the ACT and Mundi case that I opened before lunch, and all the cases subsequent to it which have followed the Trading Society test. So I have a copy of that particular extract. It's just, again, 1 page of this edition, page 83. Do we have... Are they in the black files? So it's simply a 1-page extract which should assist.
So he's still editing this textbook?
Yes.
Thank you.
Thank you.
Thank you.
Heavens, that's a bit of a mouthful.
There's no shortage of...
No. Good.
About halfway through the footnote, a sentence begins, the full court of the Federal Court of Australia adopted Lord Wilberforce's approach in ACT and Mundi. And he then goes on to say, as did Mr. Justice White, and so on in the Victorian Court of Appeal and all the other cases set out there.
Good. Well,
so
we'll,
that seems to be a comprehensive
we'll
list.
work our way through as
It's
many of
never-
those as we
It's
want.
obviously been a vigorous subject in Australia, but not in
Indeed.
Canada or...
I'm not quite sure why, sort of commercially or culturally, that would be the case, but it certainly seems to be a fruitful source of litigious dispute in that jurisdiction.
Is that because they don't have the same sort of legislation that we have, possibly? Or?
It may be. Or it may be that just lawyers are more alert to these points in that jurisdiction than elsewhere.
Doubt it.
Yes, and the next,
So
the next
my
matter?
next task was to pull together some supplemental authorities, and I hope you all have a black file. You're about to get a black file? Not quite. It's not quite ready, but I do have copies then of the two cases, Hind and Gray, which is a lessor lessee case, and Aberdeen Varieties, which is actually a conveyance. But they're both referred to in Lord Wilberforce's judgment. So we have copies of those. And then we've also put together copies of Section 84 of the Law of Property Act 1925 as originally enacted. We have Section 28 of the 1969 Act, which was the amending legislation. And we have then the current version, as it were, showing the relevant enactments to
Well
Section
done.
84.
Well
so
done.
we have all that material.
And that's coming up soon.
Yes, and I don't intend to open the English and Welsh legislation. If anything occurs, I could come back and reply, but I rather suspect it speaks for itself. It is different to the Northern Irish, but has many of the same characteristics, my lord, my lady.
Yes.
My further task then was to identify the adjoining land, the land that isn't.
Indeed.
And we've been successful in doing that. I think we've an agreed position on that. What we have for the court's benefit in our black folders are some additional maps, one of which shows freehold land owned by Peninsula Securities, which is adjacent to the land that was the subject matter of the original.
Adjacent to the folio land?
Yes, adjacent, a different folio, adjacent to the subject folio.
Right.
I'll show you that. In fact, there are two parcels of adjacent land, but one has been subsequently acquired.
Well, look, the bundles are coming up now, so please explain this when we've got the plan.
Yes. My thanks, I have to say, to all those who worked so hard over the short adjournment to pull all this together. It was a
Mr. Humphreys,
effective use of time.
It's been a very good effort.
Very grateful, my lord. So I hope there's a...
It's immaculate.
The Ms. Gray's chambers and my instructing solicitors deserve all the credit, my lord.
Yes. Now, the plans are behind 8.
Okay. So 1, 2, 3, 4, 5, 6.
And 9.
Yes. 9, I hope, is a composite map which illustrates the points I need to make without going to the others. So if one looks at this, I hope it's this one with a green area and a yellow area shown on the map.
Yes.
We go back to our understanding that the leased lands are small letter C to the right of the map. The car parking area is shown in grey and the leasehold lands outlined in red. Peninsula Securities are also the owners of 2 parcels of adjacent land, LY 97519, which is a separate freehold title, and which was owned by Mr. Shorthall, presumably. I can check that, but I presume he owned that personally at the time he entered into the lease with Dunn Stores, and it's since been transferred to the limited company. So that area in yellow is
adjacent land
and is what is referred to in the 1981 lease. This other piece of land, which is shown in green, 1957L, is another separate folio of land, also owned by Peninsula Securities Ltd, but which was subsequently acquired. So it was not owned either by Mr. Shorthall or the limited company at the time the lease was entered into.
So it's not caught.
It's not caught.
By the covenant.
Indeed. So the only piece of land outside the original folio that's caught by the covenant is LY 97519.
The area bounded in red is folio land.
Yes,
The area covered yellow is adjacent land.
yes,
We can forget about the green land.
that's right. And then the land with the small green C outlined in green is the land leased to Dunn Stores. So we got there in the end, my lords and lady, I think.
Thank you very much,
In terms of
Mr. Humphrey.
identifying all the relevant holdings.
Was there anything more you wanted to add?
I think I can briefly, I've had a chance just to look at the Hind and Gray case, which seems to me to be the most relevant of the two cases which were referred to by Lord Wilberforce in his speech. It's not a particularly easy judgment.
Having said how brilliant this was, I've got nothing between 1 and 2. And I've got nothing between 2 and 3.
Oh, goodness. Famous last words, I'm
Have you
afraid.
got one?
Yes,
You've got these authorities?
yes. Would you like mine for now? I haven't really.
Thanks.
Yes, the rule is the presider always gets the deficient bundle.
Are we?
I've been handed a bundle that does have all
Excellent.
You haven't got them.
this. Yes,
I'm afraid I don't.
Hind and Gray.
I don't have them, Mr. Humphreys, either, I'm afraid.
You don't?
So, Hind and Gray.
Yes.
This is a case where the lessor was a brewer and demised premises to the defendant, brewery premises for a period of 10 years. And according to the head note, as best we can understand it, the lessor covenant, if one goes to the top of 303, 6 lines down, begins a sentence, a covenant by the lessor of a brewery that he will not, during the continuance of the demise, carry on the business of a brewer or merchant or agent for the sale of ale, etc., in Sheffield or elsewhere, or in any other manner howsoever be concerned in the said business, is void as being in a general restraint of trade.
Yes.
So this is a case where the lessor was in trade as a brewer, let premises to the defendant, and at the time of so doing, entered into this restrictive covenant, which seems to be a fairly wide capture in terms of business and territory. And it was held void as being a general restraint of trade. It's not entirely clear how that is found from the very short judgments that later on appear, but assuming that is an accurate representation of the decision, it's not a particularly surprising one, in that here you have a very general restraint, as it would have been observed in the 19th century in terms of manner and geography. The key point about it is the lessor was in that trade at the time it entered into the agreement, and the agreement effectively denuded the lessor, it would seem, of the ability to trade, and so would come within the pre-existing freedom test, if one analyse it in those terms. It may also come into the trading society test, in that whether you're a lessor or a lessee, it might be seen to be irrelevant to the outcome if you were giving away your existing right to trade by entering into a covenant. So it doesn't provide that lessors' covenants are necessarily different from lessees' covenants. They could be subject to the same scrutiny, but it's all about the factual context and the fact of existing trade.
So they're both traders.
Yes. The Scottish case is about theatres, and again has the same theme, that both the parties to the transaction had theatre enterprises located close to one another, and one entered into a covenant not to continue in that particular trade. And again, that was subject to the court's jurisdiction. So I haven't analysed that in any great detail at the moment, but it seems to me to be of a similar nature, that both parties were in the same brewing business in Hines and in the similar theatre business in the Aberdeen case. So they don't detract from my overall general principle, which is that when one's dealing with property developer or property development, that's a fundamentally different freedom that's being given up than the right to exercise one's trade.
Yes.
It may be also relevant to look at some of the cases on the last page in the footnote of Hind and Gray, which deal with assignment. So I could just draw that to your attention. I'm
Yes.
sure you'll show us anything that's material.
Yes, thank you, lady. Is there anything else I want to say? Unless there's anything further at the moment, my lady, my lords, of which I might be assistance, I obviously have a short time to reply tomorrow, and I'll address perhaps the points arising out of the Hayden article or the text
Yes,
at
I mean,
that
it'd
stage.
be helpful sometime, not now, not necessarily tomorrow, but to be satisfied that none of the cases listed in the textbook is a case which departs from your principle.
Yes, of course. We'll ensure that's done by tomorrow.
Mr. Humphreys, thank you very much indeed. Now, Miss Gray, are you going to follow? Very well. Mr. Dunlop.
May it please your lords, my lady, having listened to my learned friend's submissions, it seems to me that there are three principal issues I would like to focus on, and then develop the fourth, which is the reference he has made to Tulkin Moxey, perhaps tomorrow morning when I've looked more carefully at some of the additional authorities that have come through. What I want to address the court on, first of all, is this. It is the background to restraint of trade, which of course is a historical doctrine established from Elizabethan times, moving forward through time. And in my respectful submission, when the House of Lords in Esso came to look at the doctrine, they were looking at in the particular historical context of Nordenfelt in 1895 and some of the earlier authorities. And to do that, if I may, my lords, can I hopefully take you through the history fairly briefly and explain why we say Esso must be viewed in the context in which it was decided. And within that overarching issue, we're then going to deal with what is the current threshold test pursuant to Esso, and why we say the doctrine is engaged on the facts of this case, applying that test. I then propose, my lords and lady, to deal with the successor and title issue, why we say Peninsula can invoke the doctrine under the law as it applies. And the third issue, to which we tread perhaps with trepidation, is the question of what alternative tests might the court consider in the event it concludes that the Esso petroleum test is no longer appropriate. The recent decision of this court in Egon Zender provides, in our respectful submission, a helpful summary of the historical cases, including some going back as early as the 15th century. You'll find that authority, my lords and lady, in the volume 2 of the authorities, tab 23. The facts of that case I need not trouble this court with for obvious reasons, and in any event, of course, it engages an entirely different circumstance to the present. But at page 458 of the bundle, my lords will see Lord Wilson has set out something of the historical background of this particular doctrine. And I refer, my lords, first of all to paragraph 22. The doctrine, as observed there, my lords and lady, is one of the earliest doctrines of the common law, and is one in which, epitomising the nation that developed it, it subscribes particular importance to the freedom of all to work or to trade, or to put another way, my lords and lady, to engage in business. And I will develop that in due course. The first case cited that you will see is the Dyer's case. We don't have a copy of the judgment. This, as my lord will see, demonstrates the vehemence at that time with which the court viewed any restraint of trade. Language which was later deprecated to an extent when the court looked at Mitchell and Reynolds. But following on from the Dyer's case, which is set out there, my lord then will see, as cited indeed by the appellants, Roger and Parry was a decision of the 17th century. And commending to my lords perhaps the summary of the history within Egon's Ender, can I then ask my lords to turn within the same bundle forward to tab 20, where you will find the judgment in Rogers and Parry set out.
Backwards, actually.
Sorry, my lord, yes.
That's okay. Yeah.
So this decision of 1613 demonstrates a number of points, one of which, of course, is relevant to the present case, that certainly at that time, at least, the court was prepared to entertain that a covenant which was imposed through a lease could be subject to the doctrine. And the facts in that case as set out are that the defendant had, in taking on a lease, had promised the plaintiff that he would not exercise the trade of a joiner in a shop which had been demised to him for 21 years. You'll see that set out in the 4th and 5th line of the text. When Chief Justice Coke and Mr. Justice Crook came to consider that, you will see at the bottom of the page, 4 lines up, Mr. Justice Crook, it's 5 lines up. The doubt which at first troubled me was for the binding of now that he should not use and exercise his trade upon his livelihood. Chief Justice then said, this is not so, being but for a time certain, and in a place certain, but no general restraint there is here. And the conclusion that you will see was that because in that particular case, the restriction was for a time certain and in a place certain, in other words, not general, it was held good. But what, in my respectful submission, is relevant is that at least at that time, a covenant imposed through a lease was considered capable of engaging the doctrine. Now, moving on from Roger and Parry, about 100 years, we then come across what is, in this field, often described as the seminal judgment of Chief Justice Parker, later Lord Macclesfield, in Mitchell and Reynolds. We can see how that was approached with the movement on of time in the common law, and that judgment is found at Volume 1, tab 15. Page 299. Now this case takes a particular significance because of the way in which it developed the law of restraint of trade into what might be described as general restraints and partial restraints. But perhaps more relevantly to the present case, the first observation again to be made is, as we can see in the judgment, the defendant had assigned to the plaintiff, the second line down, a lease of a bakehouse in Liverpool Street. That was for a term of 5 years. And the defendant then was subject to a covenant that he should not within the parish during that term exercise the trade of a baker, or in the event that he did, then there was a liability to pay a bond. So again, my lords and lady, we can see that by this stage, 1711, when this judgment was handed down, again we see that leases certainly were considered to come within the doctrine. Over the page, page 301, paragraph, it's about a third of the way down, you'll see a 136 and then a reference to Rogers and Parry. So consideration is given to that judgment. And then Chief Justice Parker, later Lord Macclesfield, observes, in that case, all the reasons are clearly stated, and indeed all the books, when carefully examined, seem to concur in the distinction of restraints general and restraints particular, with or without consideration. And that, as my lords and lady will see in our submission, is a factor that still remains significant by the time the later authorities we'll look at in a moment were considered. There's a brief observation at page 303 of the views of Judge Hall. In the Dyers case, those are in any event touched upon in Egon Zender. And then we see the judgment and conclusion of the court at page 304, paragraph 197. The plaintiff had taken the baker's house, and the question essentially was who should have the trade in the neighbourhood. And the view of the court was the concern of the public is equal on both sides. But what makes this the more reasonable is that the restraint is exactly proportional to the consideration, viz. The term of 5 years. Of course, that was the term of the lease. So what that judgment determined essentially was two things in principle. One, that there was a distinction to be drawn between general and partial restraints. And two, it introduced certainly clearly for the first time the concept of reasonableness into the restraint. But as we emphasise, my lord and lady, the question of a lease engaging a covenant was certainly something that was subject to the doctrine.
Isn't that, I mean, it's between competing traders, as they say. So
I accept that entirely.
It's not really helping us very much, is it?
But one of the issues which I hope shortly to come to is why we say the definition of trade and the way in which my learned friend has described the trade of Mr. Shorthall is very much to focus on land as a developer. And in my respectful submission, when one looks at the covenant and what it does, it's not focused on land, it's focused on the person. But if I can, my lords, if I take you through the...
Yes, certainly. I was just that I thought what you're getting from this is really clear from Esso, assuming we're bound by that. Maybe.
Well, yes, but in my respectful submission, my lord, Esso was a decision which largely was based upon a sub silentio argument in which conclusions were drawn in relation to the applicability of restraint of trade into leases and mortgages, which in our respectful submission, to view in context, one must understand the reason why there is an absence of authority in this particular area. Jumping somewhat more rapidly forward in time, we come to the next, as it were, landmark decision, which is the case of Nordenfelt. That's in volume 2, and it's at tab 22. Page 432 is the page where the judgment starts. The facts are briefly set out by Lord Herschel at page 434, not relevant to the present scenario, given that it was an employment type, in fact, a transfer of a business in which the director was subjected to a 25-year covenant not to engage principally in the arms trade. What perhaps my lords may find of interest is in his judgment, Lord Herschel summarises the law as it then was understood based upon Mitchell and Reynolds at page 436. Reading from the notes of Smith. The law is described as follows, second paragraph up from the bottom. In order, therefore, that a contract and restraint of trade may be valid at law, the restraint must be first partial, second upon inadequate, or the rule now seems to be not a mere colourable consideration, and there is a third requisite, namely that it should be reasonable. Again, that draws a distinction between general and partial restraints. And that particular distinction, of course, was put to an end by, among others, Lord Macnaghten, who developed what is now a seminal test for what is a breach of restraint of trade and how one approaches the test. You'll find his views in relation to that at page 444. Third paragraph down on that page, Lord Macnaghten considers this historical distinction between general and partial restraints. And 3 lines up from the bottom of that paragraph, he says, assuming the rule to be that general restraints are void as being contrary to public policy and not on any other ground, an exception must surely arise if exceptions are admissible at all, as soon as you find that the particular case under consideration is not contrary to public policy and so not opposed to the principle on which the rule is founded. Thinking as I do, that distinction, if it exists...
What is the distinction between partial and general, as you understand it, Mr. Dunlop?
Well, a general restraint is an absolute restraint on trade, whereas a partial restraint was fixed.
You mean I will never exercise this trade anywhere? Well, is that general?
If one were
anything less, is that partial?
Well, if one were to say, taking some of the examples in the Dyer's case or the case of Rogers and Parry, a tradesman says, I shall not, or in fact, my lords, probably the best example is Nordenfelt. I shall not for 25 years engage worldwide in the arms trade, was viewed as a general restraint.
I see, even though it's limited to 25 years.
It was limited, but it was generally viewed as so broad.
I see.
Technically, yes, my lord is correct, it was limited by
quite.
But in practical terms, within a working lifetime, it was of little significance.
Okay, thank you.
Whereas a partial restraint is obviously linked either in time or place, and in particular, certainly according to the law as then applied prior to 1895, was the subject of consideration. We have, just in passing at least, my lords and lady, then over the page 445, the third paragraph down, what is now celebrated test of Lord Macnaghten as to what is a restraint of trade, and in particular, addressing the public interest. The third paragraph on that page, the public has an interest in every person carrying on his trade freely, so has the individual. All interference with individual liberty of trading, inaction in trading, and all restraints of trade of themselves, if they are nothing more or contrary to public policy and therefore void. This is the general rule, and then there are exceptions which he sets out. Restraints of trade and interference with individual liberty of action may be justified by the special circumstances of a particular case. It is in the interest of the parties concerned, and then moves on to consider the 2 interests engaged, the party's interest and the wider public interest. Now, my lords, that decision of 1895 of the House of Lords, it seems then, for whatever reason, did not become at least fully recognised or applied until 1913 with the decision in Mason versus Provident. And at this point, if I can take my lords then to the first instance decision of Esso Petroleum, because in developing the context, we say it is perhaps of some use to look at the arguments as they were advanced before Mr. Justice
I think that might well be helpful, Mr. Dunlop.
What are we looking for from your point of view?
Sorry, my lord.
What are we actually looking for?
Macata judgment is at volume 3.
Yes, I know, but what are you expecting us to find that's going to be useful?
What you find in that judgment, first of all, the argument which was developed by Esso was advanced on the key proposition that land, the engagement of land, is something that was entirely immune from the
Yes.
doctrine of restraint, which of course I accept was the same argument advanced subsequently in the House of Lords. But what is developed, certainly in the judgment, is the attempts by counsel, as it were, to present authority to support that particular proposition. And as my lords, in my respectful submission, will see, it was an argument in which, in fact, no clear authority could be provided and was considered by Mr. Justice McCata as an argument sub silentio. In other words, in the absence of authority to the contrary, suggesting that leases were engaged where people hadn't brought claims historically, arguing that a particular lease gave rise through a covenant in it to the doctrine of restraint of trade, therefore it must be an accepted principle of law as established that they were immune. And in our respectful
Well, the
submission...
cases you've shown us show that's clearly wrong.
Sorry, my lord?
The cases you've shown us show that that's clearly wrong.
Well, it certainly was applied in the 18th century in Mitchell. It was applied in Rogers and Parry. But what happened, my lord, historically, is that from about 1805, the Tide Brewery, breweries became engaged in this development of a contract tying particular publicans to property subject to covenants that they would only buy beer from that particular brewer.
I'm sorry, I don't want to take you. I think you better go to the case because I'm diverting you and you'll
Well,
tell us what you want to
In terms of ESSO, my lord, at first instance, if you turn to page 867 of that bundle, and Mr. McGarry had been advancing the argument that the principle could not apply to land, and at paragraph F, the learned judge was considering, well, why is that? Why is there this absence of authority? There's a number of reasons given. Is the conspicuous failure of the authorities to deal with this problem due to chance, the failure of counsel to take the point, or the relatively late development of the Nordenfeld doctrine in its present form, or some other cause not based on legal principle? And we can then see, turning over to page 868, making good my submission in relation to Mason and Provident, paragraph C. However, it was not until the later decision of the House of Lords in Mason versus Provident and Supply Company that the reasoning of Lord Macnaghten in the former case was held to embody the law. So, pausing there, the law of doctrine of restraint of trade changed somewhat dramatically in 1895. The House of Lords no longer continued to apply the long-established principle from Mitchell of distinction between partial and general restraints. That led to Lord Macnaghten's now celebrated test, but for whatever reason from 1895 until 1913, it did not, or was not seen, Lord Macnaghten's exposition of the test was not seen to embody the law. So what that meant was that when Mr. Justice McCata was considering the submissions which were put before him, he had to come to a conclusion as to whether or not the Nordenfeld doctrine was one that could be applied to land, because that was the key argument put before him by Mr. McGarry. And the conclusion that he reached was, of course, that the doctrine of restraint to trade is one which could not be applied to land, and therefore, in the context of the Esso case at first instance, the doctrine was not engaged at all. Now, the timing of the judgments is of perhaps some relevance. McCata J had handed down his decision in which he concluded that land was essentially immune from the doctrine, and a few months before or after, Mr. Justice Buckley had handed down the first instance decision in Petrofina versus Martin, in which he had come to the opposite view. And therefore, before the House of Lords came to look at ESSO on appeal, the judgment was handed down in Petrofina in 1963, and that is the next case to which I would ask my Lords to have regard. And that is found in Authorities Bundle 2, and the judgment's at tab 19. Just briefly take my Lords to the facts. They are set out from page 366. Petrofina, as you'll see at paragraph E, on the 1st of April 1963 entered into a particular arrangement with the first defendant, Mr. Martin, and that was respective a particular service station. Prior to that, 6 years earlier, Petrofina, as we can see, had entered into a solus agreement which was similar in all important respects with two other people, Frederick and Gailey. Money had been advanced to those two individuals, and the solus agreement which they had entered into was a set out at G to continue for 15 years from 1958. We can see at the top of the next page, a mortgage or legal charge was entered into by Friedrich and Gailey, charging the site with repayment to Petrofina, and under the legal charge, the covenant was given that the garage would be A, kept open, and B, used only to sell fina petroleum products. Paragraph C, they then transferred the site to Mr. Ellis and Gailey, and then by early 1963, Mr. Martin, the first defendant in that case, became involved in negotiations with a view to acquiring the property. And as we can see at F on that page, Mr. Martin, coming to acquire that property, was at all relevant times aware of the existence of the solus agreement relating to the site and knew, as a condition of the sale, that he or the company that he proposed to set up would have to enter into the new solus agreement. And in fact, we can see then he himself personally signed that solus agreement with Petrofina. So, factually, Mr. Martin, in that case, was coming to acquire a site that he knew was tied, a site in which the vendor to him was subject to a covenant to ensure that in the sale to Mr. Martin, that Mr. Martin would enter into a separate solus agreement. So looking then, my Lords, at the judgments, we find the judgment of the Master of the Rolls starts at page 382.
Sorry, page?
382 is where the judgment
Page two,
starts.
thank you.
He then sets out the facts, which we have just looked at in summary. And we can see the findings at first instance are set out at page 385 at E. Buckley J. had held that the solus agreement with Petrofina was invalid because it was in restraint of trade and declined to grant an injunction to prevent Mr. Martin or the new company only trading with ESSO, a competitor of Petrofina. And then we see the statements of perhaps more general principle to be found in the decision of the Master of the Rolls at page 386. Now, one perhaps observation worth making in relation to the facts of that case are, of course, Mr. Martin, who was coming to the site, with knowledge, of course, that he would be expected to enter into a solus agreement. He himself was giving nothing up whatsoever. He was entering onto this site, and he was entering into an agreement in which he was going to be subject to this obligation to acquire petrol from Petrofina. Now, it is true that a distinction may be drawn because, of course, in distinction from ESSO, Mr. Martin did not enter into a lease or a mortgage which imposed that obligation upon him, but nonetheless, applying, as it were, looking at Lord Reid's test in its purest form, Mr. Martin was not giving anything up. He was simply coming to the site. And what the Master of the Rolls, later Lord Denning, then observed, that we say, my lords, are some significant points of principle, relevant and significant in the context of what is restraint of trade all about. Paragraph B, at page 386, every member of the community is entitled to carry on any, I emphasise any, trade or business. Now, the use of the word business, does that have any particular significance? Well, what we say, my lords, is this, and this we say is entirely consistent with the doctrine, a doctrine which is about public policy. Trade should not be defined and is not to be defined in a very narrow sense. It's of course easy to say that trade engages a baker or a dyer, a tradesman who engages in a particular form of trade. It is, of course, my lord, as we would say in the facts of this case, perhaps more difficult when one looks at someone in the context of Mr. Shorthall. But as I will hopefully develop in a moment, we say, my lords, that Mr. Shorthall was equally engaged in a trade or business which is entitled to the protection of the doctrine. And moving on then in that statement of principle, the Master of the Rolls then observes, that person may carry on that trade or business he chooses in such manner as he thinks most desirable in his own interests, so long as he does nothing unlawful, with the consequence that any contract which interferes with the free exercise of his trade or business by restricting him in the work he may do for others, or the arrangements which he may make with others. So, my lords, again, a broad definition of how the doctrine will apply. What arrangements might be made with a third party? Again, we say relevant in the context of this case. And that contract will be invalid unless reasonable, in other words, meeting Lord Macnaughton's test. Now, we can see that argument was advanced by Mr. Walton of Petrofina to limit the width of the principle by reference to a kind of restraint. And at paragraph F, the bottom of the page, we can see that Lord Denning was keen to note, as indeed were the House of Lords and ESO, that the categories of restraint of trade are not closed. As methods of trading change, so do the areas of restraint expand, and the law, of course, must keep pace with them. So then we see the next development by counsel for Petrofina. G, the last sentence, the doctrine of restraint of trade, he said, has no application to restriction of whatever nature imposed upon a particular piece of land, as opposed to a restriction imposed on a person or corporation. And that, of course, we can see was a proposition which found favour with Makata J. And as we've seen, my lords, that judgment had been handed down, and it was in contradistinction to that of Mr. Justice Buckley. And because of that distinction between the two judgments at first instance, Lord Denning then gave it particular consideration and concluded, I do not think it well founded. No doubt in our law of land, a covenant can be placed on a piece of land so as to prevent any trade being carried on there or any particular kind of trade. To such a case, the doctrine of restraint has no application. That, of course, my lord, is the standard, typical landlord and lessee type covenants, which, of course, are designed to protect the benefit of the land. What he then
But sorry, why is that not covered on your submission?
Well, my lords, the view you will see repeatedly stressed through the Court of Appeal decision in Petrofina and then in due course the House of Lords decision is that those type of landlord and lessee covenants where the lessee comes to a lease and in coming to that lease, having had a chance to review the lease and enters into it where there's a covenant restricting their use of the land, that is considered not to be subject to the doctrine. Now the question...
I mean, that's not what he says here. I mean, we know that's what the House of Lords said, but he's saying any covenant placed on a piece of land so as to prevent it, trade being carried on there.
So he says, no doubt in the law of our land a covenant can be placed so as to prevent any trade being carried on. To such a case, the doctrine of restraint of trade has no application. In other words, those standard landlord and lessee covenants where the lessee is coming to a site subject to a covenant, that he considers, no authority is given for that principle, but that he considers is not subject to the doctrine. But then there is a very important distinction. But when we come to covenants, which restrict a tradesman in the way he may carry on his trade on his own land, then we get into the realm of contract. So,
it's a funny distinction there, Mr. Dunlop, isn't it? I've got this land. I did propose to use it for trading, but I'm now going to covenant not to do so. That's not within the doctrine. That's a perfectly valid covenant. On the other, I have been trading here in this particular way for a year, and I'm now going to agree not to. That's within the doctrine, and I can apply for it to be struck out. That's odd, isn't it?
It's the distinction which Hayden in particular draws out of Lord Reid's test. That is the primary difficulty I think one can identify in Lord Reid's test. And you will see, of course, as my learned friend pointed out, the example given by Mr. McGarry in the House of Lords of various shops and various people letting to subtenants. But for whatever reason, my Lord, it is clear, and of course, we will look at Esso in a moment, but whatever reason, it is clear that before Esso's judgment was handed down in the Court of Appeal, Lord Denning seemed to be coming to broadly a similar conclusion as that subsequently drawn by Lord Reid. That is, that there is this particular distinction to be drawn in relation to someone who is restraining the way in which they may carry on trade on their own land. Now, my Lord, in terms of why that distinction might exist, there are a number of potential explanations. One, of course, is this. If I am a general tradesman and I am seeking somewhere where I can practice my trade, I am not tied to a particular location. I am free, as it were, to go to London or Birmingham or wherever I wish to seek to practice my trade. But if, on the other hand, I am the owner of property and practice my trade, and engage in a contract through which I say, in relation to my own land, from which I cannot move, I am going to bind myself not to engage in my trade. Well, that, my Lord, in my respectful submission, is a relevant distinction. Because on one hand, you are free to move and practice your trade elsewhere. On the other, as the owner of land, with all the impediments and difficulties that presents, you do not have that opportunity. And that, it may well be, my Lords, is, without being expressed in those terms, the reason why Lord Denning at least considered the distinction applied. He then set out a number of examples, none of which really, my Lords, are particularly helpful in the context of the present case, because in the present case, it is, of course, Mr. Shorthall as lessor who was seeking to restrain his future freedom to engage, we say, in trade or business. And I promise, my Lords, come to that. While we're at this particular judgment, can I just take, my Lords, to a couple of other factors which in our respectful submission are relevant. Lord Denning sought then, following the section we've just looked at, to look at the history of restraint of trade. And in particular, when we turn over to page 388, he looks at the similarities that existed between the Solus agreements in relation to petroleum and the tied houses cases in breweries. Now, that, of course, my Lord, had particular significance. The reason it had particular significance was that Solus agreements, in all other respects, had a remarkable similarity to the tied brewer cases. Rather than beer, the commodity was petrol. But in every other respect, largely speaking, the principle was the same. And what the court then had to do was grapple with here we have thousands of breweries up and down the length of the land, and thousands of publicans subject to these tied house agreements. And on the other hand, we have this relatively more newfangled Solus agreement introduced by the petroleum industry to tie filling station owners to trade with their particular petrol. Now, we say that there is then, in light of the context and history, an explanation of why that distinction should arise. What he says is this then. He says at paragraph B, If public houses can be tied, why cannot filling stations? This is so obvious a parallel that I felt it necessary to examine the brewery cases in some detail. Ever since the close of the 18th century, there are two types of public houses, free and tied. Paragraph C, he sets out, as I indicated.
What page are you on?
Page 308, paragraph C.
388.
88, yes.
Very well. Thank you.
He says round about 1805, there were several cases. These are the first examples of litigation involving the tied house type scenario. The first of those, indeed, coming before Lord Ellenborough, saw a reaction perhaps similar to that of Judge Hull in the 15th century, in Dyer's case, exploding with indignation, expressing he hoped it was the last time I shall see such a provision in any lease. So, in 1805, we can see the court, in that particular case as cited, Lord Ellenborough's surprise at the imposition through a lease of this particular obligation to purchase beer only from one source. What, of course, then happened was, despite, as Lord Denning observes at paragraph E, despite the protestations of Lord Ellenborough, the practice continued, and the judges then treated the covenants as good. And he then says at F, the reason why they were never doubted is not far to seek. They were in restraint of trade, so those covenants imposed under a lease in relation to a brewery were in restraint of trade, but they were valid under the existing rules. And then he develops the authorities from Mitchell and Reynolds.
Mr. Dunlop, I've just been inquisitively looking at what was said about the Petrofina case in Esso, House of Lords, and I've happened upon a passage at 140 at the top between A and B, where Lord Reed says, I don't think that Petrofina can be regarded as laying down a general rule. The agreement there was in unusual terms. Think the decision was right, don't agree with all the reasons. In that situation, are we right to be going into this amount of detail in the Petrofina case?
My lords, the Petrofina case obviously was a judgment available to their lordships in Esso. And I recognise, of course, that Petrofina was viewed as different because in Petrofina there was a covenant in gross. But why, my lords, briefly, in my respectful submission, the court may consider this helpful, is because when Esso was being considered, this dichotomy between the brewery cases and the petroleum cases was one that calls for explanation.
Indeed.
And Lord Denning here sets out very clearly what that explanation is. And it is simply as set out at page 389, this, that up until Norton felt, as a general principle, partial restraints, if there was consideration, were largely regarded as good, and those which were general were bad. And therefore, as he says in paragraph B, the only requisite in relation to the tied house case was that the restraint should be reasonable, and that was so as long as the brewer was ready to supply good beer at a reasonable price during the continuation of the loan of security. Such I believe to be the reasons why no one ever doubted the validity of these ties in leases and mortgages. Now, that observation, my lords, is relevant because, of course, in this case we're dealing with a lease, and one of the issues which came to light in Esso was, well, there are no cases which actually deal with this principle. Why are there not a body of authorities looking at the principle of what restraint of trade has to say about covenants in a lease? And we say that in relation to that, it's clear that because of the partial restraint rule, leases were, for consideration, were subject to a particular period of time, that for that reason, as Lord Denning points out, it is perhaps clear or likely or explicable why no particular cases came to light. And he says in paragraph, just beside F in that page, in short, they justified the tie for the same self-reason. I suggest that ties and leases were justified, that is, that they were reasonable, and up until 1895, the dichotomy of partial and general restraints was in place. Just very briefly, my lords, while we're within that case, a couple of Further observations, Lord Justice Harman's judgments at page 392.
So is Lord Denning putting the brewery cases on one side on the basis that because they were reasonable, they passed muster, and one shouldn't read into the decisions that any conclusion that the doctrine didn't apply at all?
Yes.
Is that what he's saying?
What he's saying is that the doctrine applied, but
I see.
between 1805 and 1895, in fact 1913, there was no reason for anyone or no justification to bring a challenge, because anyone looking at it would have thought that's a partial restraint.
Okay. A partial restriction really means a reasonable restriction, does it? I'm still puzzled puzzled by this dichotomy.
Well, it's a dichotomy that was developed in Mitchell. It's a dichotomy which is based upon the principle. It seems that if you're completely restrained, that's bad.
Yeah.
But if you're only partially restrained and there's consideration and reasonableness was introduced, well, that's probably
Right.
okay.
Now, you want us to go on briefly, no doubt,
I do,
to the other two judgments.
So Lord Justice Harman then gives his judgment, starts at page 392, and page 394, he says, paragraph F, in response again to the argument that the doctrine has no application to restriction imposed on a particular piece of land, he says, this I find entirely unacceptable. The person trades, not the land. And the fact that he is only restricted from trading in a particular place seems to me to have nothing to do with the matter at all. Now that, my lords, in my respectful submission, is a, as it were, useful statement. The person trades, not the land. And the only other section of this judgment, which of course is cited in any event in ESSO, was Lord Diplock's definition of a covenant restraint of trade. And my lords, at least will find that at page 397 and paragraph D. A contract in restraint of trade is one in which a party, the covenantor, agrees with any other party, the covenantee, to restrict his liberty in the future to carry on trade with other persons, not parties to the contract, in such manner as he chooses. Now, that was suggested a broad definition, not necessarily one to be applied literally, but in our respectful submission, it represents a good starting position of assessing what is a restraint of trade. So we then, my lords, come to ESSO, and my lord has already taken us to the judgment, volume 1, tab 10. My learned friend has already opened the factual background. I don't propose to repeat that. He has also set out the arguments that were developed by counsel. But in terms of the principles established by the House of Lords in ESSO, in our respectful submission, there are some general statements of principle which we would commend to the court. Lord Reid, first of all, page 134, A. As the whole doctrine of restraint of trade is based on public policy, its application ought to depend less on legal niceties or theoretical possibilities than the practical effect of restraint in hammering that freedom which is the policy of the law to protect. And then he goes on, looking, my lord, in very similar terms to what Lord Denning had observed in Petrofina. It is true that it would be an innovation to hold that ordinary negative covenants, preventing the use of a particular site for trading of all kinds or of a particular kind, are within the scope of the doctrine of restraint of trade. I do not think they are. Restraint of trade appears to me to imply that a man contracts to give up something which otherwise he would have had. This, of course, being the pre-existing freedom test. And then he says, a person buying or leasing land had no previous right to be there. The tradesman coming along with his trade to a site, well, they could go elsewhere. They did not have any right to be at that particular location, is someone to whom the doctrine would not apply. But the distinction is plainly being drawn by someone who already is in possession of the land and is contracting to give up a pre-existing freedom, some right or entitlement they already have. Now, In the facts of the present case, the way in which my learned friend has developed the argument is to say Mr. Shorthall was a developer. Mr. Shorthall was engaged in the development of land. Land should not be subject, or the restrictions imposed upon land should not be subject to the doctrine, and the authorities, as a general principle, he says, exclude leases and the covenants in leases from being subject to the doctrine. The covenant in the present case, as we looked at earlier, I take my lords just briefly to the lease. As to be found, my lords, in Appendix Part 2.
Sorry, which page are we on?
It's page 308.
That won't help Lady Arden, who's working from her screen.
It's a MS page 1909.
Thank you.
I was actually looking at it in the hard.
Oh, I see.
Sorry.
Very well. Yes?
So, the covenant is set out that any development contained on the lessor's lands, comprised in the lessor's folio and his other lands, shall not contain a unit in size, and that unit in size is for the purpose of trading in textiles, provisions, or groceries in one or more units. Now, pausing there, the question is, what is the impact, or what was the impact in that particular covenant on Mr. Shorthall? It is right that he was a developer. He, of course, had negotiated with Dunn's, one of the main players in this particular trade, and provisions, groceries, and textiles. We'll stick with textiles and groceries on the island of Ireland. He was negotiating with that particular retailer, and what they were seeking to do through this covenant was to protect their trade. The purpose of the covenant was to ensure that Dunn's were not subject to competition from someone else trading in an appropriately sized unit in textiles or groceries. The practical effect of that particular covenant was that Mr. Shorthall, who was seeking to develop a centre and to bring in tenants to occupy units within that, was restrained in relation to the type of third parties or other retailers he could approach. His trade or business as developer was to find companies or individuals to come onto his site to engage in whatever form of trade they were seeking to engage in. And he, by virtue of this covenant, was giving up the freedom to engage with many of those. So let's pick, for example, if they'd been around in Ireland at that time, Tesco's or Sainsbury's or Marks and Spencer's, all of those other players in the market seeking to occupy larger units, all of them engaging in the trade in provisions and groceries, they were a market that was denied to Mr. Shorthall.
But hang on a second. I mean, if he wanted to get his key tenant, he had to be able to offer them a degree of protection. I mean, that's, the developer is in that position, and so he obviously makes a judgment. But why on earth does that have to be subject to some sort of trade designed to protect traders against each other?
My lord, that, we say, is relevant to the question of whether or not the particular covenant was reasonable. The first question is, if one applies a particular Lord Reid's test, is the individual, the person on the land, giving something up? And we say in that respect, whatever the significance or importance it may
But
be.
anyone who contracts in relation to a bit of land is giving up some freedom he otherwise would have had.
Well,
That's the nature of the exercise.
But that's, if one applies Lord Reid's test, the owner of land limiting their chance to trade with third parties in relation to the use of that land is giving up a pre-existing freedom in the simplest analysis. Mr. Shorthall was entirely unrestrained in 1981. By the time he entered into this lease, his market was restricted. His horizons were limited by the inability to engage with other potential competitors of Dunn's. Now, I accept entirely, because to some extent one puts the cart before the horse if one says, well, of course Dunn's were entitled to some sort of covenant. That's right. But the question then is whether or not Dunn's were entitled to this particular covenant for this particular length of time. And that, of course, is a question that one does not address at the threshold stage. One addresses that in assessing, was it reasonable interest of the parties, and was it reasonable in the public interest? And that's why, my lords, we say, certainly if one applies Lord Reid's test, Mr. Shorthall falls squarely into that particular scenario. He has given up his ability as a person.
I'm sorry, I just don't understand this. I mean, he was presumably advised that he needed to be able to offer some protection to his key tenant to come in, and presumably he was advised that this was a perfectly good way of doing it, and a lawful way of doing it. And if he hadn't been able to offer that, then he probably wouldn't have got his key tenant.
Well,
So why does the law need to start coming in and imposing some sort of reasonable standard to that?
if I put it this way, what one is doing is, in my respectful submission, is saying this particular covenant on the face of it may look okay, and therefore, why would the law interfere? What we say is this, that this particular covenant is not, indeed the evidence, as the judge at first instance found, was not described by the expert called for Dunn's as a common type of covenant. The key issue was the length or duration of that particular covenant, existing for 999 years. Therefore, the land, Mr. Shorthall's, and his successors in title, almost ad infinitum, are subject to that same self-restraint.
But, Mr. Dunlop, elaborating on Lord Conworth's point, Mr. Shorthall has bought this land and has got planning permission for a shopping precinct, an area in a run-down part of Londonderry. He's desperate for a real quality, big anchor store. He goes down to Dublin and says, look, Duns, would you be prepared to come north? Duns think about it very carefully. The arrangements are made for Duns to come north and give your precinct the quality and the stamp that Mr. Shorthall wants. And then they say, yeah, okay, and we'll pay for building our unit. And then they say, okay, and we will contribute, is it half or something, to the car park creation. And then they say, okay, we will actually pay you 50,000. But in return, I'm sorry, we want this covenant. And all this is agreed. And your client has top quality advisors. And all this is agreed in a lease on the 2nd of February 1981. Are you saying that on the 3rd February 1981, Mr. Shorthall could have applied to the local court for this covenant to be declared in restraint of trade?
My lord, the picture, as it were, the picture you draw of the negotiations and the relative bargaining strength, the premium, for example, the building of the centre, those are all questions, of course, we say go to what were the interests of the parties. So, my lord, if in fact the doctrine is engaged, which we say it is, and if the court then looking at that said, on a different picture, Dunn's, one of the largest operators in the island, coming to a man who held land that he couldn't deal with because of the position of Northern Ireland in the early 1980s, in an impoverished part of the city, has a large retailer imposing or discussing terms when it has the strength of bargaining, pays less perhaps than the land is worth, imposes a covenant for 999 years, restricts him from engaging in business with anyone else with whom they might be concerned they would have to compete. Well, yes, my lord, of course that individual, we say the following day, would be entitled to come to the court and say, this is too far. I in circumstances where, as in this case, in fact, the level of advice given to Mr. Shorthall, even through the solicitor called to give evidence in the first instance decision, observed that there was no comeback or questions raised in relation to this covenant at all from Mr. Shorthall's solicitors. That, my lords, will find in the judgment of Madam Justice McBride. So,
but then on the 3rd of February, you turn up in court and you want the court to declare this in restraint of trade. Would the judge be entitled to say, Mr. Shorthall, why did you agree this yesterday?
Well, my lord, he would be entitled to say that, but of course, you could say the same in every single restraint of trade case. The next day, after someone entered into the agreement, Schroeder, the songwriter, entered into an agreement with the publishing company, and the next day, maybe a number of years before they came to the court, but the next day could have come in and said, I've thought about it overnight, I feel this is restraint of trade. And the court would have said on the facts of that case, as it subsequently found, yes, it is. It binds you in circumstances which engage the doctrine. Now, in my respectful submission, my lord, the problem with the analysis that, with great respect, my lord is seeking to draw, is it seeks to put the question of reasonableness into the test of whether or not Mr. Shorthall gave something up. And that is precisely the criticism we make of the appellant's written case. They have sought to paint a picture of the Duns, the riding on the charging horse to rescue Mr. Shorthall, and entering into an agreement where he then, with great distaste, almost like the McAllister case, where one of the memorable comments was, you can't sell the cow and seek to sup the milk. But my lord, this, we say, is not this case. And the question of whether or not between the parties in this case this was reasonable is one which no court yet has had to consider.
In fact, you can put it quite shortly. You can say the principle should be tested against a hypothesized case where the restriction goes a good deal further than is necessary or reasonable to protect Dunn's interests.
Yes. And in my respectful submission, what we are imploring upon this court is that Mr. Shorthall and, in due course, as we will see, Peninsula, are at the very least entitled to come before a court and to require Duns to demonstrate that 999 years and all the other terms in this particular covenant are ones that between those parties at that time in 1981 are reasonable. And if my lords were to conclude Mr. Shorthall, as my lord has suggested, really is acting as it were unreasonably, they'd come the next day, that is of course to do so without any evidence being called before the court, principally of what was the relative bargaining power. That issue, so far, my lords, has not been a determined fact. And in my respectful submission, all I need to do to come within the broad concept of the doctrine is say, Mr. Shorthall gave something up. Now, whether that was good or bad in terms of value, whether that was reasonable or unreasonable, is not the issue this court has to address. And to adopt, as it were, the observations from Petrofina, it is not the land that trades, it is the person on the land that trades. And insofar as Lord Reid's test is adopted by the majority in ESO is concerned, it is Mr. Shorthall who gave something up. And that, my lords, we say, is sufficient, if one applies at least Lord Reid's test, to trip that wire, as it were, to engage a doctrine. And then one moves to the question of reasonableness between the parties and in the public interest.
Are you going to show us any case where this has been applied to a developer as opposed to a trader in the conventional sense?
I'm not, my lord. I can't. But equally, of course, I could say the converse. There is no case, all the cases which are cited almost without exception in relation to leases are cases in which the issue has been a lessee having come to the site, having entered onto the site, and having engaged in a particular covenant, then later seeking to
Well, we've
challenge.
seen two cases of lessors who are rival traders being caught. At least one case of a trade and one of a conveyance. But you see, what's said against you is that the developer is not the person who's concerned. It's really his potential lessee who might want to carry on this trade. And that is the person who's caught by the Lord Reid test, because he's the person who, if he does come, is not giving up anything he would have had before. He's making a free choice.
In answer to that point, my lord, in my respectful submission, the court is addressing the wrong trade. The trade is not simply the trade in provisions and textiles, or in groceries and textiles. Mr. Shorthall is not complaining and saying, I wish to trade in groceries and textiles. What trade he is involved in his business was that of a developer. And a developer, whether it be a house builder, they require customers. There's no point developing land, it's of no purpose just to sit there. They must find customers who are going to purchase that land or take leases of that land.
And you're saying that development, even though we haven't got any cases on it, a developer's business is a trade as much as a grocer's trade.
Absolutely, my lord.
But you've got no authority to support that.
But yeah, I understand that, but I suppose, my lord, equally I can say,
It's none against you.
and there is, as we've seen repeatedly throughout the judgments, the categories are never closed. Restraint of trade as a doctrine is one which is broad in scope.
But the tendency has not been to extend it, has it? I would have thought the tendency, if anything, has been to restrict it.
One of the interesting facets, my lord, of the development of the common law has been this, that if one were standing in the 15th century in Judge Hull's court, you would have thought it's a very broad reach. In fact, if anything, what has happened is a very broad doctrine, at least Elizabethan times, has been filtered down. It wasn't a narrow doctrine which was expanded. It was a broad doctrine which has been restricted. And that is why we say, in terms of the breadth of the character of the doctrine, it is one which is broad in scope. And my submission, primary submission, is why should a developer be treated any different from a baker or any other tradesman? His trade of selling or developing land for third-party purchasers or customers or lessees to come to is equally as valid a business or trade as any other. Perhaps to adopt from ESO the words of Lord Wilberforce, you'll find those page 167.
Yes.
He says, he starts his judgment at page 166, and then he says, paragraph F in page 167, the common law has often, if sometimes unconsciously, thrived in ambiguity, and it would be mistaken, even if it were possible, to try to crystallize the rules of this or any other aspect of public policy into neat propositions. The doctrine of restraint of trade is to be applied to factual situations with a broad and flexible rule of reason. And, my Lord, we say that supports our proposition that it is a broad doctrine and it is one to be applied to factual situations. Bearing in mind that the categories of restraint of trade are never closed, and further recognising, as the judges do in ESO, and were some lengths to point out, that they were not seeking to establish a particular or specific principle which would have the effect of defining absolutely what was in and what was out with the doctrine itself. Now, what I propose then, my lords, subject to the court to do is this, to look then briefly at the review of the tests in ESO before coming to why we say, although to some extent I have touched upon it, it applies to Mr. Shorthall. My lords have seen that there were three tests essentially developed: the pre-existing freedom test, Lord Reid, supported by Lord Morrison, Lord Hodson, the sterilisation of capacity test, that of Lord Pearce, and then the trading society test is developed by Lord Wilberforce. Now, it would appear, my lords, from the commentary and the judgments that largely Lord Pearce's proposition, sterilisation of capacity test, is one that has really found little or no traction. And insofar as one seeks authority to demonstrate that, it was the High Court of Australia who expressly decided not to follow it. They did that in the 2000 decision of Peters versus Petersville. I can give my lords a note. I don't think I need to take you to the case. It's volume 2, tab 29. And at page 594 and at page 598 of the bundle, you'll see that that test was rejected absolutely. So, unless my Lords wish me to go to that.
No, thank you.
I propose, my Lords, to focus on pre-existing freedom and separately then the test adopted by Lord Wilberforce Trading Society. Now, in terms of developing these submissions, my Lords also will find it set out at paragraph 27 and following of our written case. So what, my Lords, are the problems then with the test applied by Lord Reid? Well, the first, perhaps, of those problems is, as already outlined by my Lord, and indeed identified in the submissions by counsel in ESSO, that it can elevate form over substance. Why should a distinction be drawn between a lessee and a lessor? Well, one reason is that which I have proposed to the court, because the lessee is free to go elsewhere, but the man owning land is tied to his land, and in giving something up stands in a conceptually different position from the lessee. The second problem that might arise in relation to the pre-existing freedom test is it can be evaded by sham transactions. So, for example, a lease and underlease are created for the sole purpose of including the restriction in the underlease. That, it seems, is a concern that is perhaps more imagined than real, given that a number of authorities since have demonstrated the court's ability to look through such type of transaction. And then, of course, a further point that arises is positive covenants would not be caught by it, and they can occasions be more restrictive than negative. So, for example, in this case, if Mr. Shorthall had been required to do business with a third party in a particular way, that might ultimately have been more onerous than a restrictive covenant. The example Hayden gives is, if I am subject to a covenant that I must supply 100 tons of oats per year, and I have a bad summer, and I only produce 80 tons of oats, I then have to provide my harvest and go out and buy other oats on the market. And that type of scenario would not be captured by Lord Reid's test. Moving, however, to Lord Wilberforce's test.
Why would that be a restraint of trade?
Well, you would not be able to sell your oats to any third party if you had a piece of land and your harvest was per annum 100 tons and you had to give your entire harvest to the person.
Oh, I see. I'm sorry. I will provide 80 tons of oats to you. Is that it?
But as a positive covenant, that can be more onerous than a negative covenant, because in practice, not only are you forced to give all of your own trade to the third party, you may have to go out and buy additional oats to top up the covenant.
Yes, I see. Okay, thanks.
Now, Lord Wilberforce's Trading Society test is a test which, on a number of conceptual bases, it's perhaps slightly difficult to understand how it was developed in the context of ESSO. Let me just take, my Lords, to Lord Wilberforce's judgment. You'll find that at page 166 it starts. And in particular, turning over to page 168. He says, in developing his concept, paragraph E, there will always be certain general categories of contract to which it can be said with some degree of certainty that the doctrine does not or does not apply to them. Positively, there are likely to be certain sensitive areas to which the law will require in every case the test of reasonableness to be passed, such as employer and employee. Negatively, there will be types of contract to which the law should be prepared to say with some confidence that they do not enter into the field of restraint of trade at all. How then can such contracts be defined, or at least identified? No exhaustive test can be stated. probably no precise, non-exhaustive test. But the development of the law does seem to show that judges have been able to dispense with the necessity of justification in a number of particular examples. The contracts then are developed over the page that such contracts have done or may be taken to show with at least prima facie force that moulded under the pressures of negotiation, competition and public opinion, they've assumed a form which satisfies the test of public policy as understood by the courts at the time. Now, why I say, my lords, that, as it were, is a slightly unusual application of or development of the test is ESO involved a solus agreement, which it seems was applicable up and down the country, and there were literally thousands, tens of thousands of these agreements already in force. And if one looks at that, they presumably had moulded under the pressures of negotiation, competition and public opinion. They were well established, they were frequently used, and there were many different companies and traders engaging in them. So as a trading society test, if what one does, turning over to actually see the breakdown of the test itself at page 171, paragraph D, C and D, he says, I think, and this is again in the type of transactions to which the doctrine will not apply, I think one can only truly explain them by saying that they have become part of the accepted machinery of a type of transaction which is generally found acceptable and necessary, so that instead of being regarded as restrictive, they are accepted as part of the structure of a trading society. So, what is perhaps unusual is then applying that very test, Lord Wilberforce says, this is a restraint of trade. But it is a well-established, long-standing solus agreement, which we would say has been, it seems, at least on a prima facie basis, moulded by negotiation, competition, and public opinion. So in terms of the difficulties that one then has with Lord Wilberforce's trading society test, even within the context of ESO, it's perhaps difficult to fully see how a solus agreement was a restraint of trade, but the brewery cases under that test, presumably having been round for even longer, would not be. And there are grave dangers, we say, with the application of the trading society test. Public opinion, of course, which underpins the entire doctrine, it may well not identify or see a particular evil developing in a particular restriction. What that then means is a particular restraint imposed by a standard form of contract on a significant basis may well become pernicious. But when one applies the trading society test, one is looking backwards, and that pernicious type of contract may well be viewed as moulded by negotiation, competition, and public policy, and therefore, on a prima facie basis, stand outside the restraint.
But didn't Mr. Humphreys draw our attention to where Lord Wilberforce does his best to apply his test to the solus agreements, and obviously with a degree of hesitation, comes to the conclusion that they are within the doctrine? Isn't it the bit that Mr. Humphreys referred us to on page 173 between C and D? In particular, this is not a mere transaction in property, nor a mere transaction between owners of property. It's essentially a trade agreement. Isn't that where he does his best?
My lords, why would that distinction be drawn? A restraint of trade, the entire case was an argument that it didn't involve property at all. It was an engagement between traders. That prima facie, of course, engages the question, is it a restraint of trade? But his test, in application, you ask firstly, has this become established as part of the trading society? Well, why not? A solus agreements were being operated frequently. I think in McCata J's judgment is referred to that there's something in the order of 35,000 of them. Yes. So our submission, my lord, is that, of course, as well in ESO, the court was looking at the question not only of whether the threshold was engaged, but had the evidence before it to determine was it unreasonable. And one of the significant difficulties we say arise in relation to the use of the trading society test is in order to determine whether or not the test applies, one has to engage in a very similar exercise as the question of reasonableness. One has to determine, is it common? Does the particular restraint before the court accord with what is the accepted or general type of restraint? And that, of course, is going to engage or involve the analysis of evidence. So, my lords, there are a number of authorities which, in the Commonwealth at least, have considered the application of the trading society test. And perhaps one of those which is worth looking at in terms of shopping centres at least is the Wilco versus Hudson Bay judgment, and that's in the volume 4, tab 52.
Page?
Page starts at page 1212. Because we see here in practice how the trading society test was applied in Canada. The facts, my lord, are relatively straightforward. Wilco was seeking and was holding to hold a lease in a shopping centre, and the effect of the lease which was being entered into was to prohibit Hudson Bay, one of its competitors, from engaging with it. You'll see the facts set out page 1217, paragraph 7, the judgments in English and French. The covenant being imposed through the lease was designed to ensure that Wilco would not be subject to the risk of a separate competitor. Hudson Bay was treated as one which was acceptable, being of a higher standard. But Hudson Bay had a subsidiary or a trading company which was treated as a junior department store. And the main concern, of course, on the part of Wilco was that in entering into a lease for this shopping centre, it wouldn't find itself suddenly competing against another trader operating in the same field as a junior department store. You'll see that at page 1220, paragraph 16. The court then looked at the particular terms of the lease. But the facts themselves, my lords, are not the key point. What is, in our respectful submission, interesting is when the court then came to apply the trading society test, as it did, page 1224, paragraph 30.
This is Canada now.
Yes, Canada.
And they've adopted the trading society test, have they? Or are you going to show us they did or they didn't?
Brunswick, I think, isn't it?
Yes. New Brunswick, yeah. Yeah, 30, 31.
So the paragraph 39, the court then was looking at the evidence that was presented in terms of analysing the trading society test and says, in the present case, there was no inequality of bargaining power, nor was there evidence of bad faith. Moving down to the bottom of that section, all the evidence touching on the point indicated that such covenants are common, if not universal, in leases for space in such developments, or, to use Lord Wilberforce's words in Esso, the provision is one which, by the pressure of negotiation and competition, has passed into acceptance or into a balance of interest between the parties and their customers. And on that basis, in my view, the court held the restriction in the Wilco case does not, in these circumstances, fall within the category of contract known as one in restraint of trade. That is the application of that test, as it were, in practice.
Sorry, where were you reading from then?
Page 1230,
Yes.
paragraphs 39, bottom of half of
Oh,
39
right.
into 40, my lord. So,
That's based on evidence as to how common the particular provision is that right?
exactly, my lord. And that, in this case, of course, what has not been presented is evidence before the court on the part of Duns to say this particular lease and this particular covenant is one which is universal or is common. The evidence, of course, at first instance, when the expert called, Mr. Crothers, called on behalf of Duns, was asked about this particular provision. If my lords wish, I'll take you to the judgment to make that point good. The judgment at first instance is in the core volume. And take my lords to MS 1626. You can see the evidence as was called. Earlier, just in passing, my lords and lady, I observed the question of negotiation, and I made a submission that there was limited negotiation, and you'll see at paragraph 37, solicitor giving evidence on behalf of Duns, who had been involved in the original negotiations. He says at the middle of paragraph 37, during negotiations in respect to the terms of the lease, Mr. Farrar stated, Duns never took issue with the terms or duration of the negative covenant, Hassans, they were solicitors acting for Mr. Shorthall, never took issue with the terms or duration of the negative covenant. It seems they were not adept with the intricacies of drafting or modern drafting, as he noted. But then, perhaps more importantly, we have the evidence over the page, paragraph 39 of Mr. Crothers. He was a chartered surveyor called to give evidence on behalf of Duns Stores. And about 3 or 4 lines up from the bottom of that page, you will see, he accepted when asked by the court that in terms of the return on capital, the premium for a 125-year lease and a 999-year lease was similar. Under cross-examination, he accepted he was not involved in negotiations for the lease. He further accepted that the period of time to recover the initial investment by an anchor tenant was a relevant consideration to the duration of a negative covenant. So there is no difference in premium in practical terms between a lease of 125 years and this one of 999 years. He was not able to say if it was unusual to find a covenant such as the present covenant in a 999-year lease. Now,
He says earlier on it's not uncommon to find negative covenants in favour of leases,
my
in
lords,
favour of anchor tenants.
yes, that's...
I mean, the oddity here is it's 999 years, but that's not really what we're talking about here.
But, my lord, what we say is, to use that word, the oddity, if one were to apply, as it were, the trading society test, it's difficult to see how one could say this was moulded by negotiation in light of the evidence it was called. It's difficult to see how one could make the submission that it was, as in the Canadian case we just looked at, universal. It's difficult to see how the case could be made that this particular covenant in this particular lease was part of a trading society, and the burden, as it were, rests on Duns in terms of producing evidence to satisfy that this was a commonplace covenant imposed in this particular lease. If one looks at the
Sorry,
trading...
can we be clear whether you're talking about the fact that it was 999 years, or would your arguments apply if it had been only for, say, 21 years, as under the property ordinance?
My lords, the covenant, the principal objection to the covenant is length. And the issue that then arises, if this covenant within itself at 999 years is too long and therefore is unreasonable, one then moves to the question of whether it is struck down entirely or whether there is a room for the doctrine of severance. But if some part of the covenant is unreasonable the whole of the covenant is unreasonable. Or putting it a different way, if
That's going to reasonableness. We're here dealing whether the doctrine applies under Lord Wilberforce's test.
exactly,
And
if-
he sort of brings in these issues at that stage.
if they're brought in, and the problem is, of course, in this case, if one were to adopt even Lord Wilberforce's test, in our respectful submission on the evidence before the court, the doctrine, even under Lord Wilberforce's test, is engaged, because there is no evidence in our respectful submission to satisfy the court that this is a ubiquitous or universal or common provision in a lease existing as it does for 999 years. In fact, the evidence called by an expert on behalf of Duns says, in fairly limited terms I accept, he says he couldn't say that it was common. So, in summary, my lords, why does
You are collapsing the distinction. You're collapsing the two-stage inquiry in the jurisprudence. Does the doctrine apply? If so, is the restraint reasonable? You're collapsing that, and we'll have to consider whether it is at all satisfactory for the law to provide that the doctrine will or will not apply according to the reasonableness of the terms. That may be a very unfortunate step for us to take.
That's why, my lords, we say the Trading Society test is a test which, in essence, turns what is supposed to be a threshold into looking at a question of reasonableness. So one applies a threshold test which is no threshold at all if one adopts the Trading Society test, because essentially one ends up having to call the evidence to determine, is it unusual, what are the terms, what are the provisions, is it accepted, was it negotiated, and has it accepted a within society at least, a general acceptance.
You call it the trading, I know it's been called the Trading Society test. You like that label because that leads you to make this submission about, well, this is very uncommon or not shown to be common. I'm not frankly keen on the label myself. I think that standing back, Lord Wilberforce was suggesting an incremental test, step by step, from established areas where the doctrine does apply.
Just looking, my lord, at the language, as it were, which is certainly used by Lord Wilberforce. Page 171, volume 1.
Yes.
What he's saying at C is that not, as it were, on one view, this is an incremental test to decide what should now come within the test. He is saying that certain types of restraint are excluded. So, to some extent, it's the opposite of being incremental in terms of expanding. It is saying you can look at certain types of covenant and say, that doesn't come into this doctrine whatsoever. As opposed to saying, here are all the established principal covenants tied up in this doctrine already, and do we incrementally enlarge that group by bringing in one more? And in my respectful submission, my lords, or my lord, the incremental definition or description is difficult to rest beside the way in which Lord Wilberforce develops the test at page 171.
Very well.
It's also, my lord, if one thinks about the other speeches in Esso, the general reluctance to try and define a universal rule of what is in and what is outside the test. To have an incremental test, one has to know what is already established and say, we will now take a small step further. And in this field, of course, one does not have bright dividing lines between what is in and out with the test. And in terms then, my lords, of why we say the doctrine applies in this test, at the moment we have Esso as established law, that is what the Court of Appeal applied. The question, of course, I accept...
Well, they didn't apply it in Part 2. When they got to Peninsula, they threw it over.
Yes, and
you'll come to that.
Come to that in succession.
Yeah, okay.
But what, in my respectful submission, in terms of the written case made by the appellants, I propose to simply rest on our skeleton as to why ESSO is not a tight test. It's much broader, not least because of Lord Reid and Lord Wilberforce's own comments in Macaulay and Schroeder and Pharmaceutical Society and Dixon just after it. But interestingly, my Lord, one, as it were, final authority in this field that I would take, in this area I would take my Lords to, is a much more recent decision of the Court of Appeal called Young and Evans. And you'll find that at volume 3, tab 46. It's page 1014.
(1014).
Yes, and the judgment starts, at page 1010. And this, we say, is an interesting case in terms of how, relatively recently, the Court of Appeal in England and Wales has looked at the question of a covenant in a lease and restraint of trade. It's a judgment of Lord Justice Schumann. He says at paragraph 2, this appeal raises an unusual issue as to covenants in restraint of trade.
I think it's Lord Justice Robert Walker, actually. Yes, we will.
Sorry, you're quite right, yes, my Lord.
Okay.
This appeal raises an unusual issue as to covenants in restraint of trade. The situation is unusual in that the covenant is contained in a lease of a pharmacy which forms part of a purpose-built medical centre. The lease is for a term of 15 years from 1995, and it's protected by the Business Tenancies, or the Landlord and Tenant Act in England and Wales. Paragraph 12, then, we see over the page, the lease was granted by the doctors, these are the doctors owning the purpose-built medical centre, to the pharmacist, Mr. Young. He paid a premium of just under £30,000, but in particular was subject to a number of covenants, and those are set out at paragraph 16. These are contained within the lease. The first of which is the only one we need to consider. So the tenant had entered into a covenant to use his best endeavours to procure the transfer, whether by direct or other authorisation, of the entitlement or the licence to operate as a pharmacy. And as my Lords no doubt are familiar, a pharmacy can only be operated with an agreement under the provisions of the National Health Service if a contract is issued to operate at a particular locality. So this particular locality held a contract. The contract was held by Mr. Young. Mr. Young had entered into a lease, and he was covenanting to the doctors, the owners of the site, that he would use best endeavours to procure the transfer of the authorisation giving rise to the right to use or trade as a pharmacy. Paragraph 24 then sets out the judgment at first instance. And the judge took the view that clause 3.25.2, the one we just looked at, was in restraint of trade. That has not been challenged in this court, and hardly could have been, in light of the wide statements of principle by the House of Lords in Esso Petroleum versus Harper Garage. Now, the court went on to look at the question of public interest and the interests of the parties. But there we have, my Lord, less than 20 years ago, the Court of Appeal in England and Wales, not only not demurring from the issue, and I appreciate it wasn't challenged, but expressing even the wider view that in light of the wide statements of principle in Esso Petroleum, that restraint of trade was engaged, where in that particular case, the pharmacist, Mr. Young, had entered into a covenant in relation to a lease.
Sorry, I'm just trying to understand the effect of the covenant. At the end of the operation of the lease, he was covenanting to transfer that permission. Is that right?
So if there was a relocation, that anyone else, he had because a license vested in Mr. Young, he could have a minor relocation of the contract to operate as a pharmacist to another location, leaving the medical centre bereft of a pharmacist. And what he was contracting to do was, essentially, if he was to move on, that he was to make sure someone else coming in would enter into the same contract, and therefore a pharmacy would be maintained at the medical centre. And the conclusion was, you'll see over the following pages, that in the circumstances there was a purpose-built pharmacy made available, and in those circumstances that particular covenant was reasonable.
But why would that have been subject to challenge under ESSO, given that ESSO was binding on the Court of Appeal?
Because Mr. Young, the tenant, came to a site in which he was offered a lease, and within that lease he was covenanting that, having taken on the lease, that at some future stage he would ensure that the contract which he held would be passed on. He wasn't giving up, obviously, something he already had because he held no lease. He was in principally the same position as any lessor coming to a site. Distinction may be that because he had a license.
Yes, but I mean, that's covered by ESSO, isn't it? I mean, it's not surprising that no one challenged it in the Court of Appeal, because they were bound.
I understand that, my lord. But it certainly is clear that within a lease, which one might describe as falling within the general provisions of landlord and lessee, that the lessee is entering into covenant in the lease, that in this particular circumstance, that was a covenant which was subject to the doctrine.
But anyway, the point is it wasn't challenged, but I'm not clear at the moment how it could have been challenged. But in a way, that doesn't matter because it wasn't.
It may well have been difficult to challenge it, but, my lord, it certainly establishes recently that covenants within a lease have been held to still fall within the doctrine of ESSO. My lords, I see the time. I have some fairly brief submissions still to make in relation to the application of the doctrine, and then moving on to successor and title.
So you're likely to finish well within your allotted time.
I would think so, my lord.
You're going to finish substantially before 12:30.
I would hope so, my lord, yes.
You do. Lord Carnwath.
I just want to clear up one query. Do we know why the property ordinance proceedings were apparently not pursued at all and are now dead?
The issue of restraint of trade was raised, and the judge at first instance directed that this particular issue be dealt with as a preliminary point.
Yes.
And the case then took a life of its own. To an extent that issue was found, there was an appeal, and to that extent there's no obvious explanation, my lord, other than the...
No, but they could be started again, presumably, depending on the outcome of
Well,
these.
no, it's still within the remit of these proceedings, and in due course that issue will be determined by the High Court. It's within the context of this case.
Yes.
The property order claim is still
There's nothing
there.
to stop. I mean, if this is held to be enforceable, there's nothing to stop someone from finding in the future applying to the tribunal under the ordinance.
Well, no, we don't need to apply the tribunal because the court holds the jurisdiction to deal with the property order issue. What would happen?
Oh, I do.
It was in the court.
I'm sorry, yes, I'm thinking of I'm wearing my English hat, and I'll take it off.
But of course, what would happen then, there is a distinction between restraint of trade, I'll deal with tomorrow morning, and an amended covenant. If we're right in restraint of trade, and the covenant is a restraint of trade and is one that is, whether unenforceable or void, perhaps not a lot turns in the language, it doesn't apply at all, and therefore we say, that's it, there is no
I
restriction.
understand that.
And the property order would say something different. It would say, we will amend it in some particular respect to deal with the changing circumstances and times.
I understand that. I mean, I got the impression that the property ordinance proceedings were finally dead, but the simple answer is that that could go back to the High Court if it becomes relevant.
Yes, my lord.
Thank you. Sorry,
I was looking at the defence yesterday to see whether, in response to your invocation of restraint of trade, they were saying the doctrine doesn't apply at all. I'm not sure they were, but you know the background, Mr. Dunlop. Was it McBride J. who at an interlocutory hearing said, oughtn't we to be deciding whether the doctrine applies at all?
It was, my lord, I think the judgment at first instance, in fact, if we turn to that.
Well, there's no need to turn to that.
But expressly,
just tell us whether I'm wrong or right.
You're quite right. McBride J, at a review hearing, it's just for my lord's note, MS page 1621, paragraph 4, it was the court refers to a review hearing. May not be quite the correct reference, but I can assure my lords it was the court that identified the point and suggested, in fact, directed that it be dealt with by way of a preliminary issue.
Yes.
So it was not a decision of the parties.
No. Well, thank you very much indeed, Mr. Dunlop. Then you'll look at this excerpt from Miss Justice Dyson's book, and if necessary, you'll make submissions on that, as will Mr. Humphreys in reply.
Thank you, Lord.
Then the court now adjourns until 10:30 tomorrow morning.